In this case, a contempt petition is brought up, and contempt petitions are taken into consideration on both a civil and criminal level. Civil contempt has been defined under Section 2 Clause B of Contempt of Court Act 1971 as willfully disobedience to any judgment, decree, direction, order, writ, or other processes of court, or willfully breach of an order given by the court. Whereas criminal contempt is defined under Section 2 Clause C of Contempt of Court Act 1971 as the publication, whether by words, spoken or written, or by visible representation, or by signs of any matter, or the doing of any other act whatsoever which lowers the authority of any court or trying to interfere any judicial proceeding. In this case, the criminalization of politics is the primary contributing factor to the case, which means that the participation of criminals in the politics, that person with criminal background contests the election and gets elected as member of parliament or state legislature. The idea of criminalization of politics is growing day by day and issues in the political field. And as a result, the Supreme Court of India issued several guidelines under Article 142 and 129 of Constitution to stop the involvement of politicians with criminal records in election because such criminal candidates' benefit could be harmful to the public interest. The Supreme Court has a responsibility to favor candidates with clean background over those candidates who have criminal records. The current case raises concern about how a Supreme Court has handled with this matter. Facts of the case. The current case is associated with the idea that shows how political activity is criminalized in India. Criminalization of politics refers to the person having criminal record in the past wants to enter into politics. It is harmful for the public interest because criminals enter into politics with the help of politicians. That gives political parties more benefit at large. The criminal histories of the selected candidates are not made public on the website of the political parties. This case focuses on disregarding the directions of Constitution Bench of the Supreme Court of India in the case of Public Interest Foundation versus Union of India, which is also known as the electoral disqualification case, wherein two petitions were filed by BJP leader Ashwani Upadhyay and an NGO, Public Interest Foundation. Following counsel's testimony and a review of the record, it appears that prevalence of criminals in politics have alarmingly increased over the course of last four general elections. In 2004, 24% of lawmakers had criminal proceeding outstanding against them in 2009. That number increased to 30% in 2014 and increased to 34% in 2019. It reached as high as 43% of lawmakers had criminal cases pending against them. Facts about the case. The current case is associated with the idea that shows how political activity is criminalized in India. Criminalization of politics refers to the person having criminal record in past want to enter into politics. It is harmful for the public interest because criminals enter into politics with the help of politicians. That gives political parties more benefit at large. The criminal histories of the selected candidates are not made public on the website of the political parties. This case focuses on disregarding the directions of the Constitution Bench of the Supreme Court of India in case of Public Interest Foundation versus Union of India, which is also known as the electoral disqualification case, wherein two petitions were filled in by BJP leader Ashwani Upadhyay and an NGO, public interest foundation. Following counsel's testimony and a review of record, it appears that the prevalence of criminals in politics has alarmingly increased over the course of last four general elections. In 2004, 24% of lawmakers had criminal proceeding outstanding against them. In 2009, that number increased to 30%. In 2014, it increased to 34%, and in 2019, it reached as high as 43% of lawmakers had criminal cases pending against them. The purpose of filing this case was to request guidance from the Indian Supreme Court about the ban on criminals from contesting the election and being selected as Member of Parliament. Issues raised before the court. First, why political parties offer no explanation as to why candidates with pending criminal cases are selected as candidates in the first place. Whether the Supreme Court of India can restrict the participation of candidates with pending criminal cases to participate in the election. Third, whether the Supreme Court, by making additional law, can disqualify the membership of Parliament exceeding Article 102 Clause A to Article 102 Clause E. Arguments from the appellant side. Learned counsel for the petitioner submitted that the right to contest the election is a statutory right but not a fundamental right. But it has to be followed by the pursuance of the constitutional principles in order to maintain complete governance and unprejudiced politics. Learned counsel for the petitioner also stated that not to give the chance to the person to make law who has already broken the law earlier. He should not be allowed to participate in elections and not the part of legislature. It is also expressed that the person having criminal record should not be prioritized over the candidates who have clean background in order to keep public interest at the first place. Learned counsel for the petitioner stated that constitutional principles are set for the benefit of public at large, giving ticket to the candidates who have criminal records would allow the criminals in political world. Arguments from the respondent side. Learned counsel representing the respondent stated that just because of criminal record on political candidates cannot exclude them to participate in elections. Learned counsel representing the respondent expressed that on the basis of principle of separation of powers, the respondent satisfied the basic structure was enshrined under the Constitution. It is also stated that under Article 142, there is no scope of adding the words by court in the already existing law. Judgment. The Honorable Court noted that after taking into the consideration the school of thoughts of colorable legislation, the principle of separation of powers, and examine carefully the defect of the court to issue the official documents of writ of mandamus to the election commissioner regarding the extension of law of disqualified for the explanation of the candidate having a criminal record. The Honorable Court came to the conclusion that the facility for constructing the law cannot be extended in the judiciary. According to the Article 129 and 142 of the Constitution, the court has authority to issue directions or orders. The court was aware of the growing criminalization of politics in India, as well as the lack of awareness of this criminalization among the general public. In order to close this information gap, political parties at national and state election level shall be required to upload on their website detailed information regarding individuals with pending criminal histories, including the nature of offence, case variety, etc., who have been selected as a candidate, along with the reasons of election. Selection. Political parties shall also be required to explain why other individuals without criminal antecedents could not be selected as candidates. The detailed information concerning the criminal records of the candidates shall be revealed within the native further as one local vernacular newspaper and national newspaper on the official social media platforms of the political parties as well as Twitter, Facebook, etc. These details shall be published in either two time frame, which is ever is earlier, within 48 hours of the selection of the candidate or not less than 2 weeks before the first date of filling for nomination. The political party concerned shall then submit a report of compliance with the Election Commission by following all the direction, and such submission has to be done within 72 hours of selection of the said candidate. If the political party fails to submit such compliance report to the Election Commission, shall put forward non-compliance by the political party concerned to the notice of Supreme Court of India by the way of contempt of this court orders or direction.